Rudy Giuliani is going to be disbarred in Washington, D.C. by the Bar Association that governs Washington, D.C. Today is July 11th or 12th. 4 days ago, roughly, the report from the Investigative Committee for the Washington State Bar Association, which held a hearing over several days last December, issued a report and issued their initial findings. And it's important to recognize right now that these are initial findings that are issued by the Investigative Committee in a letter addressed to Rudy Giuliani and his counsel. If you wish to file an objection to the findings or recommendation of the hearing committee, please notify this office within 10 days. So he's got some time to appeal. He's got till the 17th or 18th to file that notice that he disagrees with these findings. And their initial findings are that he be disbarred, that he have his law license involuntarily taken away from him, and that he no longer be permitted to practice law within the jurisdiction of Washington, D.C. His law license has already been suspended in the state of New York for very similar reasons that I'm about to explain to you in this report recommendation. So let's dive into this thing. First of all, on page 1, in the second paragraph, former President Trump waived his attorney-client privilege relative to Rudy Giuliani, and respondent testified at the hearing about all matters relevant to post-election litigation. Now, what's not in here? When a client waives their attorney-client privilege with their attorney, it applies everywhere. You don't get to piecemeal say, well, I waive attorney-client privilege here relative to this process, this procedure, these questions, but not over here, for example, as it relates to Jack Smith, special prosecutor. So Donald Trump waived his attorney-client privilege relative to Rudy Giuliani across the board, period, forever, all over the place, which is mind-blowing. I don't have any context for why Donald Trump made that decision. I have no idea why he did that, but he did that. And Jack Smith gets to be a beneficiary of that decision on Donald Trump's behalf, on Donald Trump's part. You'll no doubt recall that Jack Smith has gone to court several times seeking to do away with the attorney-client privilege between Donald Trump and several of his attorneys, citing the crime fraud exception with regard to Evan Corcoran and the one who actually signed the affidavit in the Mar-a-Lago case. I can't remember what her name is right now. He has litigated this several times, and he has won each time. He did not have to litigate that question with regard to Donald Trump's lead attorney, Rudy Giuliani. Trump just waived it. That's mind-blowing to me. So what's the basis for this complaint that was filed against Rudy Giuliani with the Washington, D.C. Bar Association? Disciplinary counsel proved by clear and convincing evidence that Mr. Giuliani violated rules 3.1 and 8.4D. Those are in Pennsylvania, which sounds a little weird. Those are Pennsylvania rules of professional conduct which govern how attorneys are to behave in their practice of law and how they carry themselves as attorneys, in the cases that they choose to pursue, in the claims that they bring and the complaints that they file, and how they interact with defense counsel, everything across the board. Rules of professional conduct govern how we act as attorneys. Every state's got them. Even Washington, D.C.'s got them. But why is Washington, D.C. hearing that Rudy Giuliani violated the rules of professional conduct in Pennsylvania? Good question. He violated these rules by filing a lawsuit seeking to change the result of the 2020 presidential election when he had no factual basis to do so and consequently no legitimate grounds to do so. He knew that he was filing a frivolous lawsuit. He knew when he filed this lawsuit that the claims that he was making in this lawsuit were dishonest. He knew when he filed it that he was lying. That's the crux of the claim. His prosecution of the lawsuit also seriously undermined the administration of justice and also violated Pennsylvania Rule 8.4D of the Professional Code of Conduct, which says you can't waste the court's time by filing lawsuits which you know have no basis in fact, have no basis in law, have no evidence in support of the claims that you're making. Then we go, so I'll get to the details on this for a second, but there were a couple of claims that Rudy Giuliani made. The first one had to do with COVID, that the Pennsylvania courts, the governor, changed the rules for elections to allow for mail-in voting, absentee voting during a pandemic. And you will hear the Republican talking point all over the place that, well, all of these governors in blue states changed the election laws in violation of their own state constitutions. Well, all of that's been litigated. And all of the governors who did something along those lines to allow for expanded voter mail voting or expanded absentee voting did so because we were in a freaking pandemic, okay? It wasn't safe to have hundreds of people congregate in a polling place to cast their ballots. It just simply was not. But all the Republicans are like, that's unconstitutional. That violates your state constitution. Therefore, you have to throw out every single mail-in ballot, which is ridiculous. It's been litigated in every state that this happened, and every single one of those lawsuits was lost. So that's one of the claims that Giuliani makes. He also makes the claim, also kind of related to COVID, that because of social distancing and things like that, election observers were not allowed to be like perched right over the shoulder of someone who was counting ballots, so they could see every single thing that these people are doing. Like, dude, what's going? What are you doing? They had to stay back a bit. And Giuliani said, well, because election observers couldn't be right here, then every vote that was counted by these people who were counting votes, where the election observers were all the way over there, every single one of those ballots has to be thrown out, because it means per se that the Democrats had engaged in a scheme to flip votes from Donald Trump to Joe Biden, or they had engaged in a scheme to stuff the ballot boxes with fake votes in favor of Joe Biden. And the court was like, you don't have any factual basis to say any of those things. You didn't make a factual claim connecting any of that stuff, leading to that conclusion in the complaint that you filed, or the first amended complaint that you filed, or the second amended complaint that you tried to file, which was rejected. So that's kind of the introduction. Respondent is, in this case, is Rudy Giuliani. Giuliani's frivolous lawsuit attempted unjustifiably and without precedent to disenfranchise hundreds of thousands of Pennsylvania voters and ultimately sought to undermine the results of the 2020 election. He claimed massive election fraud, but had no evidence of it. By prosecuting that destructive case, Mr. Giuliani, a sworn officer of the court, forfeited his right to practice law. He should be disbarred. That's the end of the introduction. And the introduction is only 4 paragraphs long. Now, I want to get back to one sentence in here. He claimed massive election fraud, but had no evidence of it. So remember during the January 6th committee hearings, and they brought in that guy, Rusty Bauer, who was the Speaker of the House for the state of Arizona. Lifelong Republican, Trump supporter, voted for him twice. And you remember when he was testifying live on television before the committee, he said, well, yeah, I mean, Mr. Giuliani came in and he was like, well, I have a lot of theories, but I don't have any evidence. And Rusty Bauer was like, I didn't know if that was a gaffe. I didn't know if he misspoke. I didn't know what was happening. He had a lot of theories of widespread voter fraud across 7 or 8 states, including Arizona, but he didn't have any evidence in support of it. But he wanted elected state officials, Republicans in the state of Arizona, to overturn the results of Arizona's election in 2020. So all of this is connected, and this was a scheme that was being run out of the White House, out of the Oval Office with Donald Trump and Mark Meadows and Rudy Giuliani, and they tried to get all these individual states to flip their election results. Remember the phone call that Trump made to Secretary of State Raffensperger in Georgia? Indictments coming soon. Uh, they had no evidence. They just expected Republicans across the country to be loyal to Donald Trump and go along with these schemes that they were coming up with. All right, so that's section one, introduction. Next section, findings of fact. This section is based on the documents and the testimony and the evidence that was presented to this committee, excuse me, which this committee has determined to comprise the factual record upon which they're going to make their decision. The issue about, well, there was another issue too. There were some counties in Pennsylvania that for mail-in ballots would allow the voter to cure their ballot, meaning they could fix their ballot if they screwed something up on it. And that was litigated before the election. And Trump was like, nah, you can't do that. And, you know, we'll come back to that in a second. So they give some history. In 2019, Pennsylvania, which is a commonwealth, not a state, not a lot of people know that. I don't know the difference between a commonwealth and a state. That is a video for another day and a question which we will not explore here this evening. But they're a commonwealth, they're not a state. In the 2020 general election, based on a law that was passed in Pennsylvania in 2019 by a Republican state legislature expanding mail-in voting, in the 2020 general election, more than 1/3 of Pennsylvanians voted by mail. To vote by mail, they have a bit of a complicated process. You've got your ballot. You have to put that in an envelope, which is called the secret envelope. You have to put that envelope inside of another envelope, which you have to sign. And if you screwed any of that up, they could throw out your ballot. So the state was like, if that happens in 2020 counties, you might want to consider letting your voters cure or fix those errors so that their vote is counted. Because every election law in the state of Pennsylvania and every judicial interpretation of election laws in Pennsylvania leans towards, let's find a way to make this person's vote count, which seems reasonable. Now, one of the claims that Rudy Giuliani made was that, well, the election observers who should be allowed to be right here when the people who are counting the ballots do their initial inspection to see whether or not a ballot needs to be cured, these people should be allowed to say, you should throw that ballot out right then. And there's no law in Pennsylvania that provides for that. And so that was part of his claims. So here's an important sentence that I wanted to get to. On election day, officials canvassed the mail-in ballots to verify that the appropriate information was on the outside of the larger envelope. If it was, then the secret envelope, which was inside and contained the ballot, would then be opened and the ballot was counted. Now, the first three words of that sentence, on election day, are extremely important here because, as is true in many, many red states, in the state of Pennsylvania, the Republican state legislature passed a law years ago that said mail-in ballots, it doesn't matter if they come in a month before election day, 2 weeks before election day, a week before election day. You cannot look at them, open them, or count them until election day itself. And on election day itself, you will count in-person ballots first. You will count in-person ballots first, then you will get to the mail-in ballots. Well, 1/3 of the total votes cast in 2020 were mail-in ballots. And because Donald Trump and Republicans had been screaming about mail-in ballot fraud for months prior to the election day in 2020, the vast majority of people who cast their vote by mail in Pennsylvania were Democrats. So what is the effect of that? And I'm going to remind you of some audio from Donald Trump here in a moment. The effect of that was when you count the in-person votes cast on election day, that included almost every single Republican who voted in the state of Pennsylvania. So towards the end of the day, the end of that night, when they were counting the in-person ballots, Trump had a huge lead. Well, later on in the night, then they got to the mail-in ballots, which were almost exclusively cast by Democrats. So what happened overnight? That's right, Donald Trump's infamous video. Do you remember that big fat dump, that big giant dump that took place overnight in Pennsylvania? They counted all the mail-in ballots overnight. And that's when Joe Biden took a lead over Donald Trump, who had been leading all throughout the day until the polls closed that night. When they started counting the mail-in ballots, that's when Joe Biden took a lead because almost all of those ballots were cast by Democrats. They were cast legally by Democrats according to Pennsylvania law. So election day comes and goes. And, well, let me back up for 1 second. Getting back to the election workers canvassing the mail-in ballots and partisan observers, The Trump objected to that distancing between election observers and ballot counters in Philadelphia, as they also made similar objections to votes cast by mail in Atlanta, Detroit, Milwaukee, and Phoenix, and in Philadelphia. Those are all in swing states that Joe Biden won, that gave him the election victory by that Saturday. I think it was November 7th in 2020. But what do those 5 cities have in common? Not just the fact that they're in swing states. Atlanta, Detroit, Milwaukee, Philadelphia have huge populations of Black Americans. Phoenix in Arizona has an absolutely massive population of immigrants from south of the border. So these challenges in these 5 swing states, particularly Georgia, Michigan, Wisconsin, Pennsylvania, and Arizona, a huge component to these challenges was race, because old white Republicans don't like it when people who don't look like them vote, and the votes cast by those people are actually counted. And they were trying to get the votes cast by those people thrown out. You can't ignore that factor in this case. You just can't. So after Election Day, Giuliani files a lawsuit. Well, First, the day after the election, November 4th, 2020, then President Trump asked Mr. Giuliani to take charge of post-election litigation challenging the voting results. Mr. Giuliani went to a war room in Arlington, Virginia, where he immediately met with other attorneys to prepare to bring litigation in approximately 10 states, including Pennsylvania. As part of that process, Rudy Giuliani hired an old buddy of his to serve as the lead investigator to find instances of voter fraud across the country. That guy was named Bernard Kerik, Kerik. Bernard Kerik was the police commissioner of New York City under Rudy Giuliani for many years. They are good friends. I strongly encourage you to Google Bernard Kerik. That dude has more scandals than you can shake a stick at. In addition, Giuliani engaged John Droz, D-R-O-Z, who described his career as, quote, trying to defend science. Mr. Droz was retained to assemble statistical models testing the legitimacy of the election. Mr. Giuliani started work on litigation specific to Pennsylvania after receiving a telephone call complaining about the observational boundaries, the distance between the observers and the people counting the ballots, in Philadelphia during the mail-in ballot canvassing there. Now, don't forget, not for nothing, but if I'm recalling correctly, there were a couple of Trump supporters that during that week got arrested outside of or near the ballot counting facility in Pennsylvania or Philadelphia, and they had like guns in their truck because they believed Trump's lies. And they're like, "Oh, we got to go save the election. They're stealing the election. Well, I got a gun. I got a pickup truck. You want to go to Philly? Yeah, let's go." And that was basically the thought process of these couple of gomers that, like, okay. Election challenges based on state law were required to be brought in state court. This was true of almost every lawsuit that Rudy Giuliani filed. Elections are governed by states and state law. I'm going to read that sentence again. Therefore, election challenges based on state law were required to be brought in state court. Why did I read that twice? The Supreme Court case recently issued a decision in the case of Moore versus Harper out of North Carolina. What did Republicans want in that case? They wanted the Supreme Court to recognize the batshit crazy legal theory of the independent state legislatures as it relates to elections. What they wanted was the Supreme Court to say that state legislatures had exclusive dominion over elections conducted in those states, including federal elections, elections for federal office, and that the rules, legislation, regulations that state legislatures imposed on those elections cannot be overseen and are removed from the jurisdiction of state courts within those states. If the Supreme Court had decided that case as, yeah, we agree with that, and that had been in place in 2020, then no state court would have been able to do what state courts did in 2020, which said to Republicans, you can't do this. You can't overturn these election results. You can't appoint fake electors, and Donald Trump would be our president today. So that's the importance of Moore versus Harper. So after the election, Mr. Giuliani helped draft a complaint on behalf of Donald Trump for President Incorporated, and on behalf of two individual voters in Pennsylvania who had mailed defective ballots but had not been given the opportunity to cure them. Those individuals cast those ballots in counties that had decided not to adopt the procedures to allow voters to cure their ballots. He filed the complaint on November 9th, 2020. He filed a First Amendment complaint. He wasn't licensed to practice in Pennsylvania at the time. The court admitted Mr. Giuliani pro hoc vice on November 17th, 2020. Pro hoc vice is a Latin term. It's basically where you tell a court, I'm licensed in that state. My license is in good standing. May I temporarily be licensed to practice in this state? And the court says, sure. And he tried to file a Second Amendment complaint, blah, blah, blah. The Giuliani complaints were factually deficient. I'm going to read this here. The complaint and the amended complaint challenged the location of observational barriers and the existence of the notice and the cure procedures, but neither complaint factually linked either of those circumstances to widespread improper voting. They contained only vague and speculative allegations about random and isolated electoral irregularities, which did not and could not support Giuliani's inflated legal claims. So I did a TikTok a couple days ago where I was like, with the impeachments that are coming up that Republicans are talking about, and with everything that's going on in the House Oversight Committee, the Judiciary Committee, and Jim Jordan's Weaponization of Government Committee, you're going to hit a point in all of those things where it's like the rubber has to meet the road. And that's what the court is saying here. You can make all of these allegations. You can go on Fox News and say, oh, we got this whistleblower. We lost him for a month, and I know he just got indicted on 8 felony counts in New York, but we got a whistleblower. You're going to hit a point where you got to put up or shut up. And that's what the court is saying here. He's making all of these allegations, but he has absolutely no evidence to support any of them, and he knew it. He knew he didn't have the evidence before he filed this complaint or the amended complaint. He knew that what he was filing with the court was dishonest and disingenuous. For that reason, the district court found that plaintiffs had presented only strained legal arguments without merit and speculative accusations unpled in the operative complaint and unsupported by evidence. Calling something discrimination does not make it so. I'm going to skip ahead a little bit because I'm wordy and I'm talking too much. Mr. Giuliani, however, contended that the distancing was per se fraud that he had personally witnessed. Turns out that was a lie. He claimed there was a deliberate scheme of intentional and purposeful discrimination against Trump and Republicans, and concluded, therefore, that Democrats stole the election in this Commonwealth, and that he had hundreds of affidavits supporting his assertion. These claims were simply not true. Mr. Giuliani did not offer any evidence that fraudulent mail-in votes were actually cast or counted. In his view, the allegations that he was making were enough. The allegations were enough. He didn't have to back it up with any proof. Turns out he was wrong. Because canvassing absentee and mail ballots subject to observational boundaries was a planned fraudulent process, he argued, virtually all of the almost 700,000 mail-in ballots in Philadelphia and Allegheny counties should not have been counted. Weird that he picked the 2 counties that have the highest population of African American voters in Pennsylvania. I'm sure that was just a coincidence. Acknowledging that observational boundaries applied equally to both parties, he rationalized that Democrats weren't allowed to see these things either, and so you couldn't count any of these ballots because all Democrats were crooked. And that this necessarily led to fraudulent counting of mail-in votes in favor of President Biden to the detriment of Donald Trump. I mean, he's just stretching and stretching and stretching. Well, it's like, I saw X, Y, and Z. Therefore, every mail-in ballot that was cast in Pennsylvania was in favor of President Biden and was also fraudulent and should be thrown out. and the court is just sitting there, or the investigatory panel throughout this throughout this initial decision is essentially just over and over and over again in very eloquent language. They're just sitting there going, dude, what the hell are you talking about? You have nothing to support any of this. All right, let's skip ahead a little bit. So, okay, respondent Giuliani thus commenced litigation. He filed a complaint and an amended complaint, tried to file a second amended complaint without evidence that the core factual claims he was making in these complaints were true. He had absolutely no evidence to support any of this. And at the time he filed these complaints, he knew that he had no evidence to support any of the claims that he was making. So let's talk about so Giuliani testified that a complaint is a prediction. It is not a statement of what you definitely are going to get, what you are definitely going to prove. This is the brilliance of legal research. The investigatory board went back to a statement that Rudy Giuliani made in a Supreme Court case in 2009, which held that a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. Threadbare recitals of elements of a cause of action supported by mere conclusory statements do not suffice. A conclusory statement is basically saying, this is true because I'm saying it's true. You don't have any evidence in support of it. It's true because I said it's true. And he wanted to throw out all of the mail-in ballots in two counties that had huge populations of African American voters, almost 700,000 ballots. I think Biden's margin of victory in Pennsylvania in 2020 was somewhere around 80,000 ballots. So it wasn't Georgia, 12,000 ballots. It wasn't Arizona, 12,000 ballots. It was 80,000 votes. Getting to the conclusion of this section here, let me find it. There was one part that I wanted to get to. I know it's in here because I highlighted it. They threw out all the evidence that Bernard Carrick had come up with, and they threw out all the evidence that this guy John Draws had come up with, because when those guys were both called to testify before the investigation board, they were like, well, they were under oath. They were under penalty of perjury, and they didn't back up their own evidence. And so Mr. Giuliani had no evidence to support a claim that the notice and cure procedures affected the votes in the defendant counties sufficient to approach President Biden's 80,000 vote victory margin. Without such evidence, Mr. Giuliani had no legitimate grounds to bring an injunction that would prohibit defendants from certifying the election results of 2020 on a statewide basis, or for an injunction that would throw out the votes of all of these people and prevent the state of Pennsylvania from appointing their duly elected electors to go vote in the Electoral College. We'll get to the fake electors in a second here, because Pennsylvania was one of 7 or 8 states that did the whole fake elector thing. But the people who did this in Pennsylvania, the Republicans who did this in Pennsylvania, did this in a pretty smart way that no Republicans in any other states did. And that's why all the Republicans who signed up as fake electors in all of those other states are being prosecuted for this, and the ones who did it in Pennsylvania are not. So let me tell you why. When the fake electors in the state of Pennsylvania signed their fake election form, it contained language that was conditional, not absolute. The ones in all the other states were absolute, not conditional. Pennsylvania said, the language they used said that we will only be the electors for the state of Pennsylvania if the Trump campaign won any of its dozens of election related lawsuits, and none of those lawsuits succeeded. So the condition failed. And when the condition failed, the fake electors in Pennsylvania were no longer putting themselves out as fake electors. So they're not going to be criminally charged for that. Crazy. So Giuliani was charged with violating two rules of the Pennsylvania Code of Professional Conduct. Rule 3.1, which states in relevant part, a lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact for doing so that is not frivolous, which includes a good faith argument for an extension, modification, or reversal of existing law. That's 3.1. The other rule, we'll get to it in a minute. So that's the first rule. So he did not bring this lawsuit in a good faith basis. He did so knowing that it was frivolous. I'm going to speed this up and skip a few of these things here, and we'll get to the conclusion. So there were some prior court rulings on this about the distancing for the election observers. So Giuliani stated in one of his complaints, Democrats who controlled the defendant county election boards engaged in a deliberate scheme of intentional and purposeful discrimination against Trump by excluding Republican and Trump campaign observers from the canvassing of mail ballots in order to conceal their decision not to enforce those requirements and to count absentee and mail ballots which should have been qualified. He goes on to say almost every single one of those ballots was in favor of Joe Biden and should therefore be thrown out, which was dumb. Mr. Giuliani's argument that he did not have time to fully investigate the case before filing his complaint is singularly unimpressive. He said to the court, I'm filing this complaint and I'm making all of these allegations, but it's so early in the process, I have not yet had time to investigate any of the claims that I'm making in my complaint, and essentially said to the court, trust me, bro. That's exactly the argument that he made to a frickin' court. Rule 3.1 goes on basically to say, a lawyer may only pursue lawful and ethical actions. A lawyer with excessive and misplaced zeal breaches his obligations, his ethical obligations, when he litigates a case that has no factual basis. And they found that this case had no factual basis. Let's get to the next one. The judge who heard one of these arguments on one of Giuliani's motions found Giuliani to be quote unquote unhinged. His name was Judge Brann, Brann. Even assuming that they can establish their right to vote has been denied, which they can't, Giuliani seeks to remedy the denial of their votes by invalidating the votes of millions of other Pennsylvanians. So Giuliani filed a complaint saying, hey, these two individuals that I found did not get the opportunity to cure their ballot. Therefore, you should throw out every other single mail-in ballot in the entire state. And this judge was like, dude, you are bonkers. This is simply not how the Constitution works. Okay, the second rule of Pennsylvania Code of Conduct, Professional Code of Conduct, 8.4D, prohibits a lawyer from engaging in conduct that is prejudicial to the administration of justice. Clogging the courts with unnecessary and frivolous cases is such a violation. Giuliani brought a case that had no factual support. It caused an astonishing waste of the resources of the district court, the Third Circuit Court, and multiple defendants in a compressed time frame. Giuliani violated that rule. Then we get to the conclusion. Sanctions. What is the punishment that this investigative board is seeking against Rudy Giuliani? Disciplinary counsel recommends that respondent be disbarred, Giuliani. Discipline is not intended to punish Giuliani, but instead to serve to deter Giuliani and others from engaging in similar misconduct in the future. In this case, Giuliani committed 2 disciplinary rule violations. The issue of dishonesty strikes closer to the mark. We cannot clearly and convincingly say that Giuliani intentionally lied to the district court in connection with the Pennsylvania litigation. He's not charged with that. But his rash overstatement claiming that the election was stolen has no evidence in support of it. His utter disregard for the facts underlying his complaints, or lack thereof, denigrates the legal profession. And man, the conclusion here is a frickin' barn burner. So I'm going to read 2 of these pages. Giuliani has not acknowledged or accepted responsibility for his misconduct. To the contrary, he has declared his indignation. He is shocked and offended at this disciplinary process. I really believe I've been persecuted for 3 or 4 years. In view of Giuliani's intransigence, we are convinced that a sanction must be enhanced to ensure that it adequately deters both him and other attorneys from acting similarly in the future. He didn't accept responsibility for his actions. He didn't express remorse. He was snotty about it. And because he was snotty about it, the investigatory board was like, yeah, we're going to bump your punishment up a notch because of how you're behaving. Finally, public confidence in the courts, the law, the legal profession are very much at stake in this unprecedented case. It's never happened before. We cannot blind ourselves to the broader context in which Mr. Giuliani's misconduct took place. It was calculated to undermine the basic premise of our democratic form of government that elections are determined by voters. The Pennsylvania claims were carefully calibrated to blend into a nationwide cascade of litigation intended to overturn the 2020 presidential election. Since John Adams established the precedent in 1800, no president until 2020 used frivolous claims of election fraud to impede the peaceful transition of presidential power and disenfranchise hundreds of thousands of voters. And no lawyer had done the same. No presidential candidate, no president had refused to accept defeat and step away from that office. Giuliani's effort to undermine the integrity of the 2020 presidential election has helped destabilize our democracy. His malicious and meritless claims have done lasting damage and are antagonistic to the oath to support the Constitution of the United States of America that he swore when he was admitted to the bar. Here's the stinger. We have considered in mitigation Giuliani's conduct following the September 11th attacks, as well as his prior service in the Justice Department and as mayor of New York City. But all of that happened long ago. The misconduct here sadly transcends all of his past accomplishments. It was unparalleled in its destructive purpose and effect. He sought to disrupt a presidential election and persists to this day in his refusal to acknowledge that he's done anything wrong. For this reason, we unanimously recommend that Mr. Giuliani be disbarred. Like I said, it's quite a read. It took me back to December, late November and December of 2020 when all of this stuff was going on every single day and we were watching it on TV every single day. And then January 6th happened. I was working from home on January 6th. I had a Zoom hearing at 3 o'clock West Coast time. And I remember getting on that hearing with the judge who was up in Sonoma County and my opposing counsel. And she was like, okay, are we ready to proceed? And opposing counsel and I were just kind of like staring at the screen. And I was like, they just tried to kill members of Congress and overturn the election. Are we really going to have a hearing on whether or not we're going to continue a trial date right now? And the judge was like, yeah, we are. And defense counsel and I were like, okay, all right. And we did our hearing and life moved on. And here we are. Yeah. So on that note, Rudy Giuliani is going to get disbarred in Washington, D.C. The full board is going to accept this recommendation. And I just lost my thing.